Today's case is about hearsay, and it's a great one. Of all the rules of evidence, it's by far the most complex. For example, here's the cheat sheet for hearsay. In this appeal, the defendant attacked his mother with a few of the blows striking her face. As is common in domestic battery cases, the victim failed to show at trial. The prosecutor then wishes to admit statements the victim made to the 911 operator and the ER personnel that treated her at the hospital the night of the attack. Defense counsel obviously objects, but the judge allows it in. Guilty verdict is reached, and this appeal follows. Now, every first-year law student knows hearsay is inadmissible, but, there are a lot of exceptions. One of those is called an excited utterance. Now, an excited utterance requires three things. One, something startling occurs that results in a communication, like someone screaming to you on the phone about being attacked by a family member. Two, there just wasn't enough time for someone to sit down and kind of concoct a bogus story out of thin air. And three, the victim's statement relates directly to the event. Now, what is and what isn't an excited utterance often requires a case-by-case approach by the court, and because that can be a bit of a moving target, case law gives trial judges pretty wide latitude here. In this instance, the 911 call was made shortly after the attack and fell within the case law criteria. Now, in the alternative, defense counsel says, hey, even if it's an excited utterance, it's really testimonial in nature. It goes to the heart of the issue, and I just can't cross-examine an audio recording. Now, this argument is most commonly found in criminal cases. It's called the confrontation clause. There's a case that we cite here. It's called Crawford. Crawford required the state to either have the victim testify in court, or if the victim was unable to testify, that prior to that, I was given some opportunity to cross-examine that person. But there's another exception here, law enforcement, and that includes a 911 call, or at least the portion of the call where the operator is asking for information like name, address, what happened, etc. This is a really great case that lays out the criteria on whether a 911 call, whole or in part, qualifies. Now, as for statements made to the ER, that actually falls within a different hearsay exception. Statements made to medical personnel for treatment. A real simple example here, a victim goes to the ER with a swollen face and the doctor asks, hey, how'd you get that? Now, if the doctor had asked something a little different, like, what did your attacker look like, that probably goes beyond the scope of medical treatment. Ultimately, the appellate court sidesteps this argument, however, because counsel didn't timely object to this at trial, and a failure to object constitutes waiver, in most cases. So the guilty verdict stands. Anyways, that's all I have. Thanks for watching.